Yeah, welcome to the SLW-646, if I have not been mistaken. And read what I typed on I posted on the screen.
Types of settlement of dispute: negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement. The methods of peaceful settlement of disputes fall into three categories. First one, diplomatic method. Second, adjudicative method. And the third one, institutional method.
And we discussed what is the diplomatic method. It is nothing but the above which is shown over there. Negotiations, inquiry, mediation, conciliation, arbitration, judicial settlement, etc. Even the office also. When you come to the diplomatic method, these are all the things will come over there. And the adjudicative method through the court. What are the courts? Tribunals, International Court of Justice, or any court where the parties are agreed together. And the institutional method, organizations, regional offices, and those are the methods that you would adapt. So if you happen to see our syllabus, see, I will show you the syllabus.
Yes.
See, this thing we covered already. Dispute settlement in international law, the nature and type of the disputes in international law, we covered. The doctrine of peaceful settlement, disputes and legal basis, dispute with the adjudication, court and tribunals. These are the adjudication by the tribunals. And the settlement dispute with the arbitration also. And the settlement of the dispute by the diplomatic methods, non-litigation means inquiry, negotiation, mediation, conciliation, diplomatic means, and good offices. We elaborately dealt in this one. But when you come to the 2.2 is concerned, the systematic and institutional issues in the international dispute settlement system. When you say institutional issues in the international dispute system, there we can come across the regional offices, and there we have to concentrate on it. So if you just to see here, okay, I will open the another file. Yeah. So peaceful settlement of dispute by regional organization. How the regional organization will settle the dispute. So the regional organization is nothing but the institutional. Do you agree?
Yes, Prof.
It's an institution. It is not
an institution, yes.
It is not a judicial adjudication. So, when you see the Article 33(1) of the Charter of the United Nations requires the parties to any dispute, the continuance of which is likely to endanger the maintenance of the international peace and security. See, every time that they will come across the same words, it endangers the maintenance of this international peace and security. It's a common saying. To seek, first of all, a solution by any of the peaceful methods enumerated therein. So what is the peaceful method enumerated? Then we could think it. There are many methods I told you that like a diplomatic method and the education method, institutional method. And Article 52 of the Charter recognizes the right of the members of the United Nations to establish a regional arrangements or agencies for dealing with such matters related to the maintenance of the international peace and security. Because, like human rights, we have the 3 regional centers. We studied. Is it not?
Yes.
What are they? European Union, there is Strasbourg. And there the International Human Rights Center is there. And Washington, D.C., the American Human Rights Center. What about the Africa?
Okay.
Arusha.
There is There is Arusha and Addis Ababa.
That is African Union.
Yeah, the African Court of Human Rights. It's a commission, yes.
It's a commission, that is. The court is concerned, Arusha is there.
Yes.
These are the regional centers, institutions, which will make the dispute solved. Like we have only one International Court of Justice is there where the states are the parties regarding the dispute. But whether the human rights are for the international disputes, they are the regions also there. And these regions will resolve the disputes. So perhaps 2 of the article requires the member states that are members of the regional arrangements or agency to make every effort to achieve the peaceful settlement of the local dispute through such regional arrangements or by the regional agencies before referring them to the Security Council. Like when you want to file a case, can you directly go to the High Court or Court of Appeal? Answer, no.
No, Professor.
The reason is exhaust the local remedies first. Means the relevant jurisdiction where the court is there, depending upon the nature of the case and the pecuniary jurisdiction, and you have to file the case. In case if you wrong also filed, they will suggest you, this is not the competent court to entertain this case, and they will suggest you to file it in the different court. So it seems that the obligation imposed upon the members of the state by Article 52(2), it is consistent with their obligation under the 33(1) of the Charter. However, paragraph 1 of the Article 52 imposes the 2 explicit limitation. I am sure that you cannot remember all this Article 52 and which article will make it a certain things. But as per the articles are concerned, which Charter of the United Nations requires, the parties try to resolve their disputes amicably without any friction in the regional agencies or regional courts. So the first, it requires that the matter dealt with must be appropriate for the regional action. Second, it requires that the arrangement or agencies and their activities are consistent with the purpose of the principle of the United Nations, means nothing but jurisdiction. Whether that court is or agency or regional office having a right or the jurisdiction to entertain such a case or not. In the region, there are the member states are there. When the member states are there, they follow the rules and regulation of the region. So moreover, a third explicit limitation is imposed by the Article 54, which requires that the Security Council should all the times be kept fully informed of activities undertaken or in contemplation with the under regional arrangement or by the regional agency for the maintenance of the international peace and security. So it is the bound duty of the regional agencies, it is the bound duty of regional offices. They are supposed to send the report time to time to the Security Council. Am I right? Even the district court, could they say, send the report to the High Court, their cases disposed of, their record? Could the High Court will
Yes.
send it to the Court of Appeal, their cases disposed, and how many acquitted, how many convicted? The record should be maintained. And it is the Court of Appeal will make all those things. In the same manner, if I not be mistaken, Security Council will make it from the regional offices.
No. Yes.
Is it?
Yes, it is, Prof.
Even the Supreme Court, the Court of Appeal also asks the High Courts how many cases are pending. And they want to make the record also. Because Ministry of Legal Affairs will ask the question if it is raised in the court of in the sessions. Am I right?
Yes, Professor.
You should be answerable. And in the
Yes,
same manner,
Professor.
Security Council will ask that how many regional officers are there, how many regional offences are there, and what are the cases they dealt it and disposed of. The record should be sent to the Security Council. So, no similar explicit limitations are imposed with regard to the duration of the other procedures for a specific settlement. See, the point is, use any method and see that amicably, peacefully, the international dispute will be resolved without encouraging the state security, without encouraging the state obligations.
Okay.
So Article 52 is not only confined to the legitimizing regional arrangement or agencies and imposing an obligation upon the member states and goes beyond such a legitimation and obligation by placing a duty on the Security Council itself. So we sometimes it's difficult to remember the which article says in particular charter for the legitimizing the regional arrangements or agencies and imposing an obligation upon the members states. In the each region there are member states are there, and but goes beyond such a legitimation and obligation by placing a duty on the Security Council itself. It means that the regional agencies and the regional institutions should have to send the report. If they fail to do so, then the last resort is Security Council will come into the picture. Like, if the local remedies are exhausted over there, even the High Court failed to do a particular thing, then the Court of Appeal will deal such a case. In that manner,
Okay.
it will be done in the same way. So paragraph 3
Yes.
of this article requires the Security Council to encourage the development of the Pacific settlement of a local dispute through such a regional arrangement or by such a regional agencies, either on the initiative of the states concerned or by the reference from the Security Council. So what I want to clear it is there, it is the regional agencies and regional bodies that try to resolve the dispute in an amicable manner and without the disturbing the peace of the state or encroaching on the state sovereignty of the other state. So, all the initiative of the states concerned are by the reference from the Security Council. If they could not resolve it, then they can report to the Security Council for the rescue. So, this provision is in harmony with the general approach that the charter related to the Pacific settlement of dispute, which requires the parties themselves to seek a solution to the dispute by any peaceful means of their own choice, and that the council could give every opportunity to the parties to do so. So the Security Council gives the opportunity to the each state, those who are members of the regional agencies or regional institutions. You can adopt any method, but try to resolve the issues in amicable way, so that the matter should not reach to the Security Council for interference. Is it clear?
Yes, Prof.
If any dispute would be there, if any matter would be there, if it is not resolved by the head of the department of the faculty of law or school of law, then we will approach to the dean. If the dean also could not resolve the issue, where do you approach?
Vice Chancellor.
Do you go to the vice chancellor directly? There is no DVC, academic or administration.
Yes, DVCA.
You have to go to the DVC. Even the DVC could not solve the problem, then you can go to the vice chancellor. Am I right? You
Yes,
cannot
Professor.
approach the Security Council directly. You should have to resolve the issues. Those who are party to the agencies or international, that the regional institutions or the agencies, they follow any mechanism and see that the matter will be resolved. So if the parties have referred their local disputes to the Security Council before making any effort to achieve the settlement through the regional arrangement of the agencies, then the council is under duty to remind them for their obligations or refer to such a dispute its own initiative, such arrangement or agency. And no one can approach to the Court of Appeal. If anybody approaches the Court of Appeal, they will say the approach to the High Court. Even the High Court says approach to your district court or the residence magistrate court if it falls in that jurisdiction. So the Security Council will assign the matter to the local agencies and local bodies to see that the matter would be resolved in the respective places. See, when you approach to the High Court, let you presume it. When the matter is a Monza court and the settlement is in the Monza court, even the High Court says that give the direction to the district magistrate court if it is a civil matter, residence magistrate court. Okay, entertain the case now and give the report to us if it is necessary or resolve the issue at your level and bring the report to us. Again, they refer to the local court only. Is it clear? So
Yes,
the
sir.
Security Council will refer the matter to the regional agencies, to the regional courts, or regional organizations, institutions, to see that the matter will be resolved in their local level only. So the main question of course, how should one choose the suitable means of settlement? For instance, if the wife and husband dispute is there, say in Malimbe, can they go to the Darussalam to file a case? Yes?
No, sir.
Where they have to file a case? Malimbe comes into which jurisdiction? Which court jurisdiction? If it is a separate court is there like a family court, yes, they can file it. If there is no separate court like a family court, then they should file it in the respective jurisdiction. But before it, no, they try to send it to the reconciliation agencies.
A diplomatic way. Diplomatic means of settlement.
Yeah, they will send to the reconciliation organization. They will send to the institution. See, marriage is a natural bond, and one should have to keep it out. Otherwise, it is a disaster. You have the children. Now the children who will take care of it. So they want to reconcile it, and they try to resolve the issues. I don't know here. If a person is married, can the second day he can file a case for the divorce? Yes.
Must pass it to the board. They must pass to the board of reconciliation.
In India, you cannot file a case till the 1 year is over, or an extraordinary case is 6 months. But the matter will be referred to the reconciliation board. Even if the divorce also be given, it will be implemented only after the 6 months later the decision. Of course, now the new amendment has come. The mutual consent is there. So upon that, they can take the divorce, not following the period of it also. Provided it is the discretion of the court to see that the life becomes a miserable over there, then only resort is to sanction the divorce. So that was the actual case. So in the same manner, international law imposes an obligation to settle the dispute by a peaceful means, but unless the parties have agreed otherwise, there is no obligation to resort to a specific mechanism, state can choose between the diplomatic and judicial means. They can approach it by the diplomatic means. They can approach by the judicial means. They can approach by the regional agencies. Overall, that what you want is a peaceful settlement between the parties. Is it or not?
Yes, it is, Professor.
If a woman and a man is living under one roof and having a children and there is no dispute at all, can anybody will go to the court that they are not married? Unless until he is having interest in somebody's wife. Am I right?
Yes,
Yes,
sir.
Prof.
Nobody would care whether you're married
Yes,
or
Prof.
not married. Unless until the matter goes to the court. In the matter of inheritance, in the matter of succession, in the matter of any other things. You can make your own inheritance by giving that property to the people. When there is no dispute at all, nobody will go to the court. Unless until he is having the extramarital child. Even the extramarital child also entitled for the inheritance. Am I right? Answer is yes. Are you following me? No fault of the child. Why the child should be punished?
Yes, Prof.
So that is the reason. So states can choose between the diplomatic or judicial means. By any means they can make it out. If they come to the conclusion that they are settled disputes, could any other agency will interfere in it? Answer is no. So the first ones includes the whole gamut of procedures and with the difference among them, not always clear cut. And you see that a layman could not understand the language of the court because the words are aristocratic in nature. Why they so? If a common man understand, nobody would approach to the lawyer. It's a common thing. And it is not always true, but the mostly it is a true. What characterizes all the diplomatic means in the lack of the binding effect of the report, which may be prepared at the end of the process, and the possibility to take into consideration all the relevant circumstances, diplomatic means are by either their nature friendlier and less adversarial than the adjudication. Either you follow the institutional method, either you follow the adjudication method, either you follow the diplomatic method, either you follow the non-legal method, any method you follow it. If the parties are agreed over there, then those things are binding. The binding will not come at that instance when the parties disagree. Is it clear?
Yes, sir.
Although the submission
Yes,
to the
Prof.
arbitration, yes, the submission to the arbitration or a court of law, it is optional. Once the tribunal has made its decision, the decision is a binding because it is a judicial decision and has to be implemented. Either it is a tribunal or the court having the equal position and power regarding the implementation is concerned. So arbitration is more flexible and can better be adapted to the wishes of the states or parties to the dispute, in particular with regard to the choice of the arbitrators and the rules to be applied. So You can adapt any method, but see that there would be an amicable solution should come out between the parties. So proceedings at the international court are certainly more rigid. International law has to be applied and the procedure foreseen by the statutes and the rules of the procedure has to be followed, but with the possibility to opt for adjudication by chambers. You know, summary trials. Do you follow the summary trials, all the procedure? I don't think that you will follow all the procedure in the summary trials because they want to see that the matter should be resolved. So, not necessarily that they will follow it, all the norms of the procedure. So, procedure has to be followed when it is a adjudication by the judicial bodies. But when your matter comes to the arbitration or matter comes to the dispute resolution system, then the parties agree to that one, the court will endorse it and it becomes a binding. So there would be a, I don't know whether it is there in India, whether in Tanzania. They will arrange, especially national, what I say, national, okay, because there is a legal authority is there in the national level, National Service Legal Authority, District Service Legal Authority, and State Legal Service Authority. And these legal service authority, they try to solve the disputes by amicable means in the form of resolution of the either in the form of arbitration, in the form of settlement of the dispute by calling the parties. Otherwise, it will be the innumerable cases will be piled up in the court. Whether such a system is there in Tanzania. They call the parties and they will see that amicable solutions will come out. There, one judge also be there. If the parties agree together and the witnesses are not witnesses exactly, the judge and the other members, those who are with them, they also endorse it and the stamping would be done and that is a binding one. Are you following me? So that
Yes, bro.
cases will be disposed. Do you have such a mechanism in Tanzania? Where the parties will be called by the legal service authority, especially insurance cases and especially family disputes or petty land disputes, not murder cases, not rape cases. Are you following me?
Yes, sir.
They try to make it out. In India, we say Lok Adalat. Lok means people's court. People's court it is. So that is the concept they developed it to see that the dispute will be resolved. Otherwise, a person winning also cry, a person who is losing also cry. But the only difference is the person who won, he cries at the home. The person who loses, he cries at the court. Only that is the difference. I don't know whether you followed my point or not. Because both are the losers. Number one, regarding the time. Number two, tension. Number three, money. What is the use of winning after 30 years? Are you following me?
Yes, sir.
So history shows that most cases of dispute resolution involved negotiations, mediations, arbitration. Those are the diplomatic method of resolutions, solving the legal dispute. But nowadays, the list of cases on the agenda of the Hague Court. Hague Court means International Court of Justice, as quite impressive. Clearly, the peaceful settlement of international dispute is an important ideal that many international diplomats, lawyers, and commentators aim for it. In particular, international lawyers hope that international the international legal disputes should be used as an important means of resolving the dispute, or international law can be and should be used as an important means of resolving the disputes and not political, economic, and or military powers. Neither the disputes will be resolved by the political means, neither it can be resolved by any other means except in the international legal instruments, treaties, protocols, and as such observations are there. So important means of resolving the disputes not by the political, economic, and the military power. The use of the latter is often viewed as a failure of international law. If they do not follow it, the norms of the international rules, then the international law is a meager and it's become a fructuous or useless. So which indicates that this is in some way, this topic is the opposite of the last topic. So here I want to say is, either you follow the international legal instrument or you follow the any other method. But the aim of the parties is amicable solution of the dispute in a peaceful manner. So however, while in a perfect world, the use of law would be the means of resolving the dispute, we know that in reality, it is a political and economic factor that so often take precedence. See, sometimes when you want to resolve the legal dispute, the enactment which is made by the state, either state legislative assembly or the parliament, and which is in a political in nature. Those who are in political nature, they want to resolve it, or they will amend any enactments or statutes, including the constitution. So interference definitely would be there in direct way. Political interference. Generally, is the ruling party will make it according to its convenience, some of the enactments. They try to make it out. Because when you want to make the enactment or the amendment, the majority will be seen. Majority those who agree, then it becomes a law. Am I right? Participants,
Yes, sir. Yes, Prof.
sleeping. So we are listening, tell. So how do they take it? By raising the hands in the session. If any bill would be passed, there is a quorum would be there, and the quorum should have to make it a consent for that one. Then the bill will be passed. Am I right?
Yes, sir.
So thus,
Yes, bro.
yes, nevertheless, law in particular international law can play a significant role in some disputes. It is not all the things it will come into the picture. Yes, international dispute will be resolved by the legal instruments and the education bodies like the regional courts, regional tribunals, or the International Court of Justice. Thus, while we need to be realistic in acknowledging the limited role of law plays in many disputes, at the same time, we should never underestimate and we should be advocates in favor of the powerful potential of law. See, if every dispute is resolved by the amicable means, then there is an enactment of the state. If everybody is a gentleman, why the police department? Why the court? Are you following me? Participants,
We are following,
Yes, Prof.
sir.
if everybody is a gentleman, and if everybody don't want to steal, even though the goods are there, even the house is open without locking, because he is having the fear of God, and there is no question of theft. And when such a thing would be there is no necessity of the police department also. But every human being having some propensity of the criminal nature. If you curb the propensity of the criminal nature, then you can become a good man. If you don't curb it, then you can become a criminal. Am I right?
Yes, sir.
And it depends upon
Yes,
the
Prof.
attitude of a person. Suppose if somebody has left his mobile phone, and that to be Apple phone in the class. If you really a person would be there, you take the phone, you try to find out who is the owner of the phone and try to return to the person. If not, you can give to the class representative and ask him to see that it will reach to the owner of the smartphone. Could the people do if it is Apple phone? Without informing anybody, they try to take and snatch it away. It is a human tendency. If you are human, if the fear of God is there, and such a man will not do, because it is not his property, number one, and he doesn't want to take the advantage of it. Somebody is losing the phone in the class. So, however, none of the methods resemble judicial settlement. In that case, methods are not based on the application of an arbitrator, the court of tribunal, or existing law facts found by the arbitrator or court. The outcome of this diplomatic method are not binding on the disputed states. Now the question comes out there. If they don't agree, then nothing will come out. Even the diplomatic method also will not come out. But the judicial method, definitely it will come out, because there is a force behind it. Am I right?
Yes, sir.
So, anything with the force is there, people will fear. If there is no force is there, people doesn't fear. Am I right?
Yes,
If there
Prof.
is no exam, can you read it?
No.
Because you read it, otherwise you have the fear that you will fail. So, is it not the forces behind you?
In some
Answer is
extent.
yes. If the force is there, people will listen. If the force is not there, people will not listen. Ingombe, does it have the logical reasoning not to graze somebody's land? Yes. A cow or a buffalo doesn't have the logical reasoning to graze in somebody's land, because its nature is when the pasture is there, they will go and graze, even though it does not belong to its owner. Am I right?
Yes, sir.
Only the human being having the reasoning power, that is called hypothalamus. What is that? Thalamus,
Hypothalamus.
which gives the reasoning of a man. And such a thing is lacking in the animals. And hence, no doubt, a man is a social animal, but he is having the reasoning power. With the reasoning, he can know what is good, what is bad, and he can move it. So regional agencies, regional bodies, they try to resolve legal disputes in any manner they like it, if the states will agree to that and the binding you to it. If it is not binding over there, then the last resort is judicial. Sikiliza mimi darasa, asante sana na shukuru sana, Mungu akubariki na kukulinda.